Hi, my name is Megone. Thank you for joining me on this video. Today we're going to discuss something that can bring tremendous drama to your life. What happens if you don't probate a will? Granted, probate can be costly and complicated. Unfortunately, not probating a will can bring your family so much stress, so much drama, you will consider probating the will a cakewalk. Failing to probate a will can mean that you're going to disinherit someone in the will. It may mean that you're going to bring people into the estate of your loved ones that they wanted to disinherit. In this video, we will explore the most common reasons why a will should be probated. Situations in which a will may not be probated are as follows. 1. Possibly you can enter into a family settlement agreement on the disposition of the assets. Therefore, your loved one may have left a will, but all the beneficiaries under the will, you come into a formal agreement that you will dispose of the assets in a certain way. In this situation, there usually has to be no creditors, or the creditors have already been paid. The heirs enter into this family settlement agreement, this affidavit. Everyone signs it and it is filed in the real property records. If that is done and you have no third party refusing to honor the affidavit, the estate can be dissolved, the estate can be given to whoever. Affidavit, in this heirship affidavit, you have the family agreement and everyone has to sign. However, what happens if someone refuses to sign? If someone refuses to sign, you cannot escape it. You have to probate the will. It is possible to enter into something less than probating the full will. You can enter into a monumental title. In that situation, if you only have like real property and you may or may not have a lien against the house, you can enter into just a monumental title, file it in the real property records, and that's all that needs to be done. However, you may have a situation where there is a will, you want to probate the will, but the person holding the will does not want to probate it. In this situation, you may have the family member hiding the will and so forth. You have to get the will probated, and therefore some interested person, it could even be a creditor, will open the application for the will, file a motion, and then that person gets dragged into the probate proceeding and the will gets probated. Heirs do not realize that they need to probate a will is one of the main reasons why a will does not get probated. In the state of Texas, you have 4 years to probate the will. I've seen situations wherein the grandmother passed away. The grandfather didn't probate the will. The grandfather then passes away, and because all of the grandma's and grandpa's children were all their children together, the children did not probate either of the parents' will. Then, for instance, you have 6 children. Grandma and grandpa had 6 children. These 6 children have 2 or 3 children of their own. The grandparents didn't probate the will. The parents didn't probate the will. And now the children, the grandchildren, step in place wanting to, for example, sell a piece of property. Sell the piece of property that granddad and grandma had built their nice homestead on. Guess what just happened? These children have to go back, probate each one of their parents' estate, and then probate grandma's and grandpa's estate. You can have a situation like that where you may be able to get away with affidavits of heirship. However, for many creditors and many people at that time, you can't find 2 disinterested witnesses who can testify as to grandpa's and grandma's estate. And so by not probating that will, this piece of property that these grandchildren now inherit will be tied up, may even reach a place where it may be impossible to sell with clear title. That's why a will needs to be probated. You have 4 years. You have situations, however, where dad passed away and mom has all the 5 kids. She may believe that she did not have to probate the will erroneously. 4 years lapsed, and then she now wants to probate the will. It's possible in some of our more liberal courts that the court will allow you to probate this will even though 4 years have passed. However, if it goes court by court, and it all depends on that judge and that court that you're in that day. In that situation, if the court says, Mom, I'm sorry, 4 years have passed, you do not have just cause why you did not probate this will, the will was not a secret, you knew about it. Guess what? Dad just passed intestate, and dad's will is now as if he passed without a will, and all the provisions he made in the will, regardless of the fact that he may have given 100% of his estate to his wife, now passes under Texas law. It becomes even more complicated if this was Dad's second marriage, and Dad has children outside the marriage, maybe adult children, and now he's in the second marriage with minor kids, and he left the entire estate to his new wife and that mom of the minor kids. Because she failed to probate that will, these adult children that he has outside the marriage now takes under his estate, regardless of what Dad had in his will. This can be a very difficult topic, and therefore if you're in a situation like that, if you have a will, if you're not sure if you should probate it, or even if the 4 years have passed, please speak to a probate or estate planning attorney. You can reach out to us at www.brianfagan.com. Again, my name is Megone. Thank you for allowing me to share this topic with you.